Friday, we sent out a letter to Comptroller Topinka outlining the fact that there were several individuals that the Senate had received appointment messages from the governor regarding permanent appointment, but the time had not elapsed off of the 60 session days in which for these people to automatically be deemed to confirm. And as consistent with Senate practice, what has happened is anytime the clock is sort of drawn to a close where the Senate has adjourned sine die, which is what we did in the wee hours of Wednesday morning last week, governors have typically in the past simply renominated with new paperwork for the individuals that they would want to serve. So there was some continuity in that they were able to stay in office. And the letter was sent to the comptroller to ensure that, that the listed individuals were properly serving in office. We had reached out to the governor's office regarding the matter prior to us sending out the letter to the comptroller. And what we've laid out in the letter is that under our Constitution, the governor can obviously appoint subject to Senate confirmation. The Senate has 60 session days in which to confirm these individuals. But of course, the Senate, consistent with other provisions of the Illinois Constitution, the Senate comes to a close when the term of the General Assembly comes to a close every 2 years. So one Senate, a prior Senate, obviously cannot take up the action of a prior Senate. And what was captured in our letter is any of these individuals that were on the list, since they were pending Senate confirmation, we're no longer in a position to act upon those particular nominees. And it also brings into question the fact that if there's no legal authority by which them to serve pending Senate confirmation, then the individuals are serving in a position where they may not have legal authority to execute their duties, and with that receive a salary or expense reimbursements for being in that position. And what we've articulated in the letter is not something, is something that conforms to long-standing practice in the Senate. It's not only the practice of past governors, but it's the practice that's reflected by other officials that have appointment power as well. So that's the nature of the letter, and happy to answer any questions that you might have.
If I understand this correctly, this is having the effect of pushing out the holdovers that haven't acted on and haven't been renominated then?
I don't understand your question.
Appointments, let me think about it a second so I can
I guess I want to understand how long then are these people, could it be up to a year these people are still in and paid?
Let me try to. We had a number of individuals that were listed in the letter. These individuals were nominated by the governor to fill terms of office. The Senate was in session in the 96th General Assembly. The Senate, when it was in the 96th General Assembly, received that message. Okay, that paperwork was not transferred to the new Senate. By virtue of the fact that we could not take, we in the new Senate cannot take action on that old paperwork, there's no paperwork supporting the individuals to be in office today. Okay.
Are they still showing up that you know of? I mean,
I don't know.
That's a question for the administration. So
Your letter basically is saying, Comptroller Topinka, you don't have to pay these people. That's the upshot of it, isn't it?
I'm not aware of any legal authority supporting the ability for these individuals to continue to serve without new paperwork or to receive a salary.
So if point one, staying on to these folks, under your new rules, he would put them in as acting for now until the Senate comes back, or?
The governor has a couple options.
Okay.
The governor could, one, temporarily appoint these individuals under his constitutional power under Article 5, Section 9B. That person who's been temporarily appointed, of course, can only serve until the Senate next meets, which would be February 2nd. In the same letter, he could, of course, say, not only am I seeking to appoint this person on a temporary basis, but I'm also seeking to permanently appoint them. And by doing that, we call that a belt and suspenders approach, because you're not only temporarily appointing them, but also you're seeking to permanently appoint them. That would then put the paperwork in place that the 97th General Assembly can consider that nomination.
And then they would stay in the position until the Senate acted specifically on their nominee?
Then we would have the process that would follow. Again, I want to be clear that the appointment message that the governor would have to file would have to be in conformance with Senate Rule 10-2, okay?
So then if he's seeking to permanently appoint him, does the Senate then have 60 days still to confirm that?
That's correct. 60 session days, correct, from the date that the appointment message was read into the Senate Journal.
Has the Senate President's office talked directly to the governor yet about his options or what he might be thinking?
The Senate, our office has talked with, I don't know if they've talked directly to the governor, but we've talked with individuals within the administration, high-level staff.